Welcome to the Jared and Jared podcast. I'm Jared, and this is Jared.
I'm Jared as well.
Double Jared. I know it's confusing, but the good news is I have two R's. So we're both lawyers. We both like crypto, and we're going to talk about Chevron and maybe some crypto news today.
I mean, why is Chevron important to people? Well, especially people in the crypto industry. That's kind of the point of our show today. So let's go forward.
So we should probably give a quick introduction. People have probably heard of the Chevron Deference, administrative law cases. So believe it or not, Chevron is the gas station. It's the gas company. They're the oil company, man. They suck oil out of the ground, they turn it into gas, and they sell it.
And they don't like it when the EPA or anyone else tries to put regulations or tell them what to do or how to do it. But what came out of this Supreme Court case was some very, very poor law in the long run that wound up, fortunately, being overturned. Now, you'll see on the internet where they're talking about how, well, now that Chevron's been overturned, there's no more room for bureaucratic officials to run wild.
I think that's the outcome, and that's important. So it's Chevron USA Incorporated versus Natural Resources Defense Council Inc. et al., which means and others. So this is at the Supreme Court of the United States of America, and it was argued February 29th, 1984, decided a couple months later, June 25th, 1984. I think one of the interesting parts of this is that there were three abstentions. Justice Marshall and Rehnquist took no part in the consideration of these cases. Justice O'Connor, Sandra Day O'Connor, took no part in the decision of these cases. So there's three justices didn't rule on it. There are six justices that did rule on it.
Enough for a majority.
Interestingly enough, it says Marshall and Rehnquist took no part in the consideration or decision. Justice O'Connor only took no part in the decision, but she did take part in the consideration.
Yeah, and I think she kind of owed that one to Ronald Reagan. She should have weighed in against this thing, don't you think, man? Jesus. Made her the first woman on the Supreme Court.
This is some interesting case law. So, anyway, this is about the Clean Air Act from 1977. And Chevron was redoing one of their plants. And I believe if you have a permit for one of your plants, and it's a polluting plant, the rule was that if you did not increase the total emissions of the entire plant, that you didn't need a specific permit with the EPA. And they talked about a bubble the whole time. So the bubble is actually what one entire emitting company, essentially Chevron at this point, where they were using, they were taking the oil, they were refining it into, diesel, gasoline, and the bubble is the entire amount of pollution that emitted from that plant, and that was going to stay the same. So essentially, the court looked at it and said, well, the Clean Air Act is actually designed to reduce emissions, not keep the emissions the same. So what do you think, Jared? And kind of bring us through this and tell us wonderful audience why you think that this case was incorrectly held and why the EPA doesn't have the power to basically come in and decide for the courts why the Clean Air Act didn't require Chevron to file a new permit.
Well, first to start off, what we're looking at here is a decision that flies in the face of the separation of powers, if you will. The EPA, all these other agencies, Department of Labor, et cetera, these are all parts of the executive branch of the government. And, of course, that's the president, the vice president, and the people that they appoint to enforce the different laws, etc. So what wound up happening as a result of this Chevron decision is that these agencies would, they have to interpret the law in the course of doing their job. How else would they know to not not arrest someone, etc. But what this case did was say, look, if this agency interprets the law in a specific way, and if there's more than one, we're talking about sort of either vague statutes, if you will.
Yeah, I think that's an important concept, is to remember that if the statute is vague, then this is where the deference that they gave the EPA comes in. So if it's very clear and there's no contradictions in it, then it wouldn't apply. And as you know, probably every one of the federal statutes could be considered vague, wouldn't you think?
Yeah, vague, very hard to interpret. And so what the court did here was say, look, if there are two ways to interpret a statute, and the agency that's charged with enforcing or the said statute says that they put forward a particular interpretation, as long as that is a permissible way that it could be interpreted, not the best way, but a permissible way, then the courts were told to go ahead and interpret the law that way. And what it does, it took interpretation of the law out of the hands of the court in these instances, which goes against the Constitution, checks and balances. And I think that I was looking back at the case thinking, what would lead them to come to a decision about, that gave this much discretion to an agency. And I got to thinking that this is about environmental quality department.
Yeah.
And so and the time that it came up was a time when certainly the environment was starting to become a very big topic and issue in the United States. And with that, I think the court and, I think everybody wanted to see some progress in environmental laws, et cetera. They wanted to see these things get interpreted and put into play and properly administered. And I think that may have led to the court coming to this conclusion. Probably did not foresee at all the trouble that it would lead to. And eventually...
It's a lot of trouble.
Into the Loper case. You've got people that are not government. They are government paid people, but they have not been elected. Their positions aren't created in the Constitution, and here they are interpreting laws, and that's being taken seriously by the courts for a while. But thankfully, Loper sorted it out.
Yeah, so, we can go through a little bit of Chevron, and then we can switch to Loper. Loper's the case that overruled Chevron, which came out just this year in 2024. So the court did a reasonable analysis, I think, of the Clean Air Act, and they said that the legislative history was contradictory, that the case again, the law was very very vague, and it literally essentially fell on whether or not this bubble theory, whether or not a new permit was needed if the entire Chevron itself wasn't emitting more pollution. This one new area was going to emit new pollution, but the whole plant itself wasn't going to emit overall more pollution. So the EPA actually said that the bubble concept was inapplicable, meaning that you couldn't use that entire Chevron facility and its emissions. You had to use the new part that was being constructed, and that is what mattered, and that had to reduce overall emissions. So, the first question in the analysis in Chevron was, is this a case, or is this a law where it's very clear. And if it is, then the court can easily rule on that because Congress, again, like you alluded to, with the separation of powers, Congress's job is to write the law. And it is not a executive branch job to interpret the law. It is the judicial system and the court system to interpret the law. And that's what I think the main issue is, and why this case has just taken an immense sort of power away from the courts, and a lot of the rulings over the years for the Chevron type of deference is where it's a very scientific process where you've got an EPA who the courts don't know anything about emissions. I mean, they may know a little, but they're interpreting a statute that's very scientific in nature, and the EPA, their argument is that, well, this is our job. We do this every day. We're scientists. We understand this. And the court, though's job is not to understand that, but to say, well, Congress didn't rule appropriately. They didn't write something that's clear, so go back and do your job, Congress. Yeah. If it was clear, we would know, right? I mean, that's the issue.
Well, yeah. I mean, if they wrote it clear, it wouldn't have come up in the first place. And so, and it's not like we're dogging Congress here, saying you should have written it clearer. I mean, although we do that sometimes in the legal profession, but look, no one's going to be able to write statutes, vote on them, and get them passed that meet that are appropriate or easy to interpret in every situation. I think it's too much to ask.
So, I mean, here's the question and the problem. So, in these cases, and especially Chevron, where let's say it's vague, the court rules that the legislative arguments back and forth are unclear as to the meaning of the statute. What they did is they said, well, we don't really know. This isn't our cup of tea. We'll allow the EPA, since they're the specialists, to decide this, essentially. So what you're doing is you're taking the judicial power of interpretation that our founding fathers decided in 1787 in Philadelphia, and now we're giving it to the executive branch. The executive branch over the years has obviously taken the most power from any other branch, and now we're giving him an additional power of interpretation, and I think that is a big problem. And the way that this was ruled in the 80s is just bad. So now if a statute is unclear and they have a administrative agency that oversees it, well, then that administrative agency is going to decide the interpretation of the law, and it's not up to the the court system. Now, I mean, Chevron is huge, and it comes up in a lot of different cases, but I think over the years it's been sort of waning, and now the final death blow has been given by Loper Bright Enterprises et al. Versus Raimondo, who is the Secretary of Commerce. Again, argued January 17th of this year, 2024, decided June 28th, 2024. So the court, and this is a quote, the very first sentence, it says, the court granted certiorari in these cases limited to the question whether Chevron should be overruled or clarified, and they voted to overrule it. So essentially what they're saying is, in these situations, the court now has to make that decision, not the administrative agency that's in front of it, and I think that's the right decision. So the court talks about the rapid expansion of the administrative process, especially during the New Deal era, and like United States versus Morton Salt, St. Joseph Stockyard versus the U.S., and also United States versus Moore, where the executive branch is interpreting these cases for the judicial branch, which again I think violates the separation of powers. So if you want to talk about a little bit about the Loper Bright case, which is kind of interesting.
Yeah, it's Loper and the plaintiffs were fishermen, and they're talking about a Department of Wildlife and Fisheries regime set of rules that required what you're going to be possibly a little bit shocked to find out about, unless you're in the commercial fishing industry. So
in the Pacific Northwest, right? That's where this was.
That's in the Pacific Northwest, but I can tell you that in Louisiana, when you're fishing oysters, shrimp, there have been similar issues, but not quite this bad. But let me get into it. So, the law required that Loper and the other fishermen go ahead and pay. Well, first of all, there had to be limits on what they were doing out there fishing, how much they were catching, etc. And in order to enforce that, well, that came to the Department of Wildlife and Fisheries, how to enforce the law. And so the Department of Wildlife and Fisheries went and passed a regulation that says that the fishermen, the commercial fishermen, have to hire this company to put equipment / put an employee on the boat and monitor what the fishermen are doing.
And this is a federal agency. This is the Natural Resource Defense Council, right? They're a federal agency. Is that how this is?
Regional Defense Council.
The Natural Resources Defense Council. That's. Oh, I'm sorry. I'm looking at the
you're
wrong.
You're looking at
it's
the
the
other
National.
case.
Excuse me. The National Marine. I'm literally reading the wrong line. It's the National Marine Fisheries Service, and that was a federal agency under the Magnuson-Stevens Act, and that is a federal agency that required when you're fishing out in international waters, I believe, to have the person that is fishing has to pay the government who is there to check and make sure that they are indeed, keeping within the limits of that Magnuson-Stevens Act. I think that is highly insane in my mind, but
paying to police yourself, I mean, we do that as attorneys. We pay the Bar Association Disciplinary Council to keep an eye on us, but I mean, like, people in regular businesses, it kind of doesn't make sense.
Yeah, but that would almost be like, in my mind, hiring a governmental accountant to come in and track my trust account that I'm already tracking, and paying their person to come in and double check what I'm doing.
Yeah.
I mean that to me is it's a tax. It's obviously, Loper Bright won and they don't have to pay anymore.
No, they're done with all that.
Which is, to me, one of the wildest things. When I read this, I was like, man, I'm glad this went to this United States Supreme Court. There's no way we need to pay our own keepers, essentially. Right. It's their job to make sure we're enforcing it.
Well, yeah, and I mean, you're going to pay this third party that we pick to watch you, and you're going to pay them what we tell you, and Congress never did it. Your country didn't actually pass this law the way that it was supposed to be passed, but by damn, you're going to go ahead and pay it. Well, thankfully, the thing got shot down. I think a lot of people like to see government overreach get shut down, except for the people in the government doing the overreaching.
Yeah, and I think the most important sentence, and I'll read it here, it says, perhaps most fundamentally, Chevron's presumption is misguided because agencies have no special competence in resolving statutory ambiguities. Courts do. The framers anticipated that courts would often confront statutory ambiguities and expected that courts would resolve them by exercising independent legal judgment. Chevron gravely erred in concluding that the inquiry is fundamentally different just because an administrative interpretation is in play. Just because it's scientific, just because there's an agency that understands things like pollution, understands marine fisheries, we should give them deference. And I think that's wrong. I think the courts are the ones that actually have the not just the idea of whether or not this is scientific. It goes beyond that. It goes, to the point of, did Congress overstep? Is this constitutional? And, there's no scientific sort of agency that can resolve that. A court system is perfectly poised to do that, and judges have the training and the education to be able to do that, and hopefully they do it well, but it's their job.
And
it's not executive job.
And judges were appointed and approved to do the job, and I mean, look, I think the Department of Labor is wonderful, and if there was any agency out there, the United States Department of Labor, I like the way they interpret the law. But my point is that they were not they didn't go through the proper channels of government to be giving to give interpreting statutes and making that binding on other folks. So.
Yeah, and I wanted to bring up another case, and you didn't get to prepare this. I'm sort of just throwing this on you. I found it interesting. I was reading, some similar federal court cases, and I'm looked at Webster, who was the director of the CIA, versus John Doe, and this is a 1988 case with Chief Justice Rehnquist, who delivered the opinion. So in 82, a CIA security officer involuntarily informed his handler at the CIA that he was a homosexual. And in 1982, apparently the CIA thought that was a very big deal and immediately placed him on administrative paid leave pending an investigation of his sexual orientation and conduct. Now imagine in 2024, a CIA agent goes and says, I'm a homosexual. They'd be like, cool, do you want to party? I don't know, right? I mean, how would that, in 2024, what would that look like if in the CIA you went up to your boss and said, hey boss, I'm a homosexual?
It would be one of two answers. Either we know or we don't care.
The CIA Office of Security determined that respondents' homosexuality, and this is a quote, posed a threat to security. So because John Doe was indeed a homosexual, he is a threat to national security. Now, I don't think in 2024 he would be considered a threat to national security.
Oh, no. I think that, one thing, if you're looking back at it, 1982, let's think about it. I think that, even though I was about 6, I think that if people were to find out you were a homosexual back in those days, it could be a very big problem for you. And so I think where the CIA is coming from is they're saying, well, somebody could get this guy in a position and blackmail him, because it's something you really would have a harder time blackmailing someone with that kind of information today. But in 1982, you could go a long way with it. I think at that time it probably was a threat to security. As far as they were concerned, they figured, some Russian figures out you're gay, takes a bunch of pictures of you with whomever, Ivan or whatever, and then that's it.
Boom, the Russians got you.
Yeah, the Russians own you, dude. They own, So, yeah, I think that back then, now it wouldn't be an issue. I don't think it would even, it wouldn't even float anyone's boat. It wouldn't turn the needle.
I don't think it's quite as saucy as it was back in the 80s. So, well, anyway, this case was handled after Chevron came down, about 4 years after. And it was interesting because there's, they even talk about some constitutional claims in here, and they kind of sort of punt on that issue. And, what they said was that there's really, this is a final agency action, and there's really no remedy in court. Quite honestly, the court looked at this and they were like, we probably shouldn't have voted to take this, is what I think at the end of the day after reading, this entire opinion. They're probably like, So anyway, the section 102C of the, I don't even know what, some CIA law that goes through it's a National Security Act. So this is 102C of the National Security Act of 1947, which basically says that the director of CIA, in his discretion, can terminate the employment of any officer or employee when he deems it necessary or advisable in the interests of the United States. So because the security found that he was a security threat, the security office found that he was indeed a viable security threat because of his homosexuality, that he was immediately terminated, and that Congress intended to preclude judicial review of the claims because they gave full deference to the administrative agency here in this case. And so in this case, I think this is a little different than Chevron because it's very clear that that Congress didn't want any court system to overthrow this because in their mind this is talking about national security, and typically national security, there's exemptions where the president and the executive branch can do things where they normally wouldn't be able to in the interest of national security. So however, not war. We can't go to war without Congress. However, we do that. How often have we done that?
Well, I mean, if you're saying, do we need a declaration of war from Congress? Yeah, but I see
Framers thought so.
We blow up all kinds of things for many days at a time. Many days, we're out there months blowing up, people, and we don't have authorization from the country, but it's for national security.
Yeah.
And this CIA deal, this is one of the bad cases that came out of this whole Chevron debacle.
And Justice O'Connor actually concurred and dissented, but she said that this is a very delicate, plenary, and exclusive power of the president as the sole organ of the federal government in the field of international relations. So Scalia dissented, of course, and said that our precedents amply show that commitment to agency discretion by law includes, but is not limited to, situations in which there is no law to apply, meaning that the Section 102 of the Security Act basically didn't allow for judicial review of anything. So, I mean, it's a very sort of muddled opinion. I probably only brought it up because of how interesting it was that if there was a homosexual in the CIA, now there's a national problem, and we've got to fire this guy immediately. And I found that funny how times change. So how does this wonderful Chevron overturning and the Loper Bright case, how does that affect our precious crypto?
Well, it affects it, I think, overall in a positive way. Because now the SEC, Securities and Exchange Commission, the second most important SEC in the country, the first being the Southeastern Conference, LSU Tigers, number one, fuck Bama. So
the vote is positive. That's a plus.
Yeah.
Okay, that's good.
Yeah, it's a positive. I'm saying it's a positive because the SEC, we don't want them to just decide what the policy is on crypto. Especially, look, I think that this also speaks to is it the big question, the unanswered question, the important question?
The major
question.
The major question. I think it really should be called the big important question.
Yeah, the super.
Yeah. So I know Jared's talking about the major questions doctrine, which in the world of crypto, I think is important because Congress hasn't ruled on whether or not crypto is a security, whether crypto should be a commodity, whether it is regulated by the SEC, whether it's regulated by the CFTC. So since Congress hasn't ruled on that, the SEC can't take over administrating crypto itself because Congress hasn't ruled yet what it is. And so maybe it's like a security, maybe it isn't. Is a SAFT, which is a simple agreement for future tokens, is that considered an investment contract? Could be. I don't know. These are all sort of pie in the sky kind of questions that haven't been answered yet. But to me, because the major question hasn't been answered by Congress, what is it? Then the SEC shouldn't have the power to regulate it until such time as Congress gives the SEC that power. And that is, again, what the framers would like to talk about as, the balance of power. And I think it's tipping, way too far in the direction of the executive branch. And, Congress sort of has lost on this. So, there's still a possibility that the major questions doctrine could get a good revival in our Coinbase case, with the SEC, or maybe the consensus case with the SEC. But but we'll see. As those cases progress, what Congress hasn't even weighed in on that yet. So this is going to be sort of an interesting, I think, 5 years. Which again, in the world of legal, that's not a lot of time. And see kind of how both the court systems and Congress, take this. And I think if Trump gets elected, I think we'll have sort of a different set of regulation than we would if Harris gets elected. So, I think that is, what a lot of people are calling the battle of crypto, to see which elected official is going to be sort of running the agenda.
Yeah, whichever one wins is going to set the rules or try to set the rules. I think, obviously this is a big election, so, and crypto is part of that.
Well, as every election states, this is the most important election of our time. I hear that every 4 years, and truth be told, I don't ever believe it. Although this one may be more true than the last one.
I think so.
I don't know.
Now it's kind of like, it reminds me of and this is coming up in this weekend and in 2 weeks. This is the game of the year in college football, and they're going to say it in week 2, week 4, week 3. This is the game of the year, and then there might be a game of the decade built in there somewhere. But they do it every fucking year, and the bottom line is that whatever, it's just bullshit. But in this case, we're talking about someone that has not spoken had not had an interview since becoming the Democratic candidate for president, and it's just been over 60 days, and she hasn't given an interview. It's just more sort of propaganda out there,
Well, we can say that the Telegram founder was Duval.
Yeah.
I think that's how you pronounce it, was arrested in France for not complying with allowing EU officials to enforce their rules of, really just clamping down and denying free speech in the EU. And we did get a letter from Mark Zuckerberg, which stated that he was pressured by the Harris-Biden administration to censor COVID-19 humor, satire, plus other posts, which I found quite interesting, in that he regrets doing that now, and that he should have spoken out sooner, which I don't know any American who didn't see that happening. So if you need a criminal lawyer, and after this podcast, I doubt you would hire either of us, but you may. We at the Bradley Law Firm do criminal. We also do crypto, which is interesting. It's an interesting mix, but we have a good team. And then, Jared does. What do you do? Let's go through it. You tell us.
I do a lot of civil litigation. I like workers' compensation. I like crypto a lot. I'm just getting into that. Very fun, very exciting, very demure, and so I like those things. But really, I just want to get on here and speak about little things that I think need to be talked about and have some fun.
This could be fun.
Yeah,
definitely. Well, I think we can say that Loper Bright is going to bring back pull the reins back on the SEC, and how that they've been sort of railroading all of the crypto companies like Library. Ripple, I think, was one of the ones that actually fought back, which, thank you, Ripple, for doing that. Coinbase is sparing no expense.
XRP.
I would imagine Coinbase spent nearly $1 million on a hearing, which at the end of the day is not going to make much of a difference other than informing the judge of what the case was about. It's a judgment on the pleadings, which I've been involved in one in my career.
They don't file them much, do they?
No. Well, I was defending it.
Yeah.
The plaintiff brought it, and we won. because you always win that. I mean, I'm sure there's been instances where people have won a judgment on the pleadings, but to me, it's not very often.
No, because they're going to give the person who messed up their pleading the opportunity to amend.
Yeah.
In general, and so.
And I think online I've seen some discussion about how the SEC and its definition of what a broker is. I think that's really important on the consensus case. So, consensus, I think, is really, I would imagine, one of the most important cases that are coming up here, shortly. So consensus runs Uniswap, which is what's called a decentralized exchange. So if you have a crypto and you want a different crypto, you can go to a decentralized exchange, you can swap it, you can buy and sell, and so when you do that, the SEC is alleging that Consensus, the company that created the software, is indeed a broker because they have software where I can go and take that software and match me. If I have, say, Ethereum and I want to buy your, say, Polygon, which is Matic.
The automatic.
Which, by the way, it's getting rebranded.
Again?
Yes.
It went from
Polygon, Matic
to
Polygon, but now it's not going to be called Matic anymore. It's just Polygon. It'll be Poly.
Poly?
Yeah. Poly want a cracker.
I like Poly. It's a good
So
name.
if I have Poly and you have Ethereum and we want to swap, the software will match us together, and then we do our decentralized wallet integrations and tap, click, boom, pay a little gas, and now I have your Ethereum and you have my Polygon. So is that a broker? I don't think so.
No, I think
it's a software. It's a matching software. So under Chevron, perhaps the court would give deference to what the SEC would define as a broker, whereas now the court has a lot more power and has taken the reins back from the SEC to actually decide those important questions. And I think crypto is going to be a better place because of the Loper Bright case.
Oh, I think Loper Bright, you are correct. Loper Bright it's taken the SEC out of it. Let's face it, the SEC is, I don't think anyone involved in crypto really appreciates the SEC's efforts thus far in the past several years. And, look, get it sorted out rather than let a bunch of government bureaucrats tell us what to do. I mean, it's kind of, I don't know, but gladly, it can't happen anymore. It's unconstitutional. You remember that, Gary Gensler, whatever the fuck your name is?
Yeah, so, and I think a lot of this, the district court cases didn't use Chevron deference when they ruled on whether or not the crypto company at hand was indeed trading insurance contracts or not, and whether a crypto falls under an insurance contract. So, a lot of those cases will still stand, but, so I don't know if it's really something that's like vastly different, but I think it certainly helps if you are a pro-crypto person. Loper Bright is certainly something that you're happy about. Let's put it that way. That's my take on it. And again, this is law, and, legislation is, slow in the court system and is even slower in interpreting that legislation. So, we'll see how the courts rule in really the Consensus and Coinbase cases. Those are the ones that I think are the most important. So, what about where we are in general with crypto? So I think we're, somewhere in the low 60s. We were up pretty close to 65, I think, in the last few days, and now it's come down. What's your take on, is this a bear market? Are we still in the bull market?
We're still in the bull market. It's the happening is very recent. and
yeah, a few months ago.
it's starting to get built into the price. But let's remember that when Bitcoin is going down, but it's not going to go down as far as it was just recently down. I mean, that stuff's getting built in. They've got now an ETF for Ethereum, which is a very, very bullish development. You not only can you get Bitcoin on it, but you can get Ethereum. And then they've got, there's all kind of cool opportunities in crypto if you're willing to look for them. One of the big things is this understanding, what it is you want to do with your tokens, and then putting them in the right place.
Here's what I'll tell you about the right place. Please, everyone, make sure if you are trading and you are putting money into any exchange, any application, any platform, that you make sure you have the proper web address. Please don't click on random links from people. Please don't just say, this looks good. This cute woman from Facebook has sent me this link. It looks like the Coinbase link. You click it. It's not Coinbase. It looks just like Coinbase. You put money on it. Your money goes up and down. It has all the cool things that Coinbase has, except when you want to take that money out, it's locked because it's not Coinbase. It's Coinbase with a zero, or it looks very different, or they've masked the web address, and you've been putting your money into a scam site. So people, get a VPN, and please don't click on links unless they're from a trusted source, and make sure you're on the right site when you're trading.
Agreed. And I think the point that I need to make here is we're talking about the private identification key. You've got your wallet, and you've got these words that you need to, have them written down somewhere so you can open and recreate your wallet.
Oh, your seed phrase. Yeah.
Seed phrase.
Right. So when you guys, first create a wallet, and I think there's probably a couple of you that are new to crypto. You get a seed phrase, which is essentially like a password. It's 12 or 24 specific words that you have to put in order. You get that. Please don't put that on any web-connected or cellular-connected device. Keep it written down in pen and ink. They actually have metal that you can stamp the words out if you want to go that route. That way, it could save you from a fire on occasion. So you want to keep one paper somewhere, another paper with the same words somewhere else, so that they're in two locations. And then you'll get a public key, which is like your address, which is a long string of numbers and letters. That you can share with people. That's your public key. That's basically your wallet address. So if someone was going to send you something, you share that. Then you also have a private key, which you do not want to share, which also would allow people to come in and transfer your funds the same as a seed phrase would. So the private key and the seed phrase, keep very safe. Public key you can share because that's your address. So, I mean, that's our sort of PSA for the day. Get a VPN, make sure the links are proper, and, contact an attorney if you have a company that is going to either sell crypto, sell NFTs, coming out with your own project. Is it safe? Is it legal? Can the SEC come after me because I'm now in the middle of an investment contract? That's what we're here for.
That's what we want to help you with, and we want to help you with the details of it, how you're going to do it.
Yeah, so, I mean, all jokes aside, we know what we're doing, and we're happy to help kind of navigate the waters of crypto in the post-Chevron world.
Indeed, sir.
Or maybe in the Loper Bright world.
Yeah, the new Loper Bright world.
Yeah, it's much brighter on this side of Chevron.
Yeah, motherfuckers don't be loafing.
Yeah, so what do you think? What's the what's the goods? What's the sort of hot trends in crypto? I'm thinking gaming is really going to be big.
Gaming is a great idea because there's always use for what you're buying. You're playing games, and let's look about how video games have changed over the years. Like now, these games, you got games online. You get your PlayStation, you're on there, and you can download a game and start playing right away. Then you can play with people on the internet. I mean, this is, to me, kind of amazing because I'm kind of old. But, but think about it, this is the next step. It's a natural next step. It's all centralized when they're playing it on a video game, and you buy it. You have to pay for example, EA Sports. You want extra points for your athletes, you got to pay for it. You got to buy it.
By the way, EAFC comes out in about 3 weeks, which is the new FIFA game, because FIFA didn't agree with a contract extension with EA Sports, so now EA has their own soccer game, and they went out and collected and contracted with the major players for their own intellectual property, except for Maradona. I don't think he's in because he recently died.
Well,
however, EAFC it's a pretty good game.
Yeah, I enjoyed the 2024 one, but I mean, I don't know all that. I've never actually played a game with crypto, but
I've played Axie. I've played Heroes of Mabia. I've played a demo of Crypto Unicorns, and also Honeyland. There's a few. I've played a few, and some of them are fantastic.
Yeah, I'd like if you could play people in Madden or whatever for money on online, like using crypto. And I mean, I think those sites are around. I don't know how to.
Well, so I think a lot of, and one of the, I've had a couple clients that reached out who are implementing online blockchain betting.
Mm-hmm.
So where you would get a smart contract, you would put up a certain amount of cryptocurrency that would be locked in the contract, and then the outcome of the game, once determined, the money would flow immediately to the winner and come out. Well, I guess they've already put it up, and it's already out of your wallet by the time you've put it on the smart contract. Then once the game is decided, it goes directly to the winner, which I think is great. And again, this is not gambling. This is skill-based wagering, which most jurisdictions do have a distinction between the two. And I think that something like skill-based wagering is going to be a huge part of what we call crypto games, which is really Web3 games, which is sort of the next iteration of the web. I think Web2 games, like you're talking about Madden, I would love to see an online, crypto sort of overlay on top of the Madden game, where you could, wager it. Now, I personally wouldn't be wagering a lot. My Madden game is a little weak, but I would really love to wager on other people playing it.
Yeah,
or just to throw up a few bucks for my friends who may also be as bad as I am. That might be fun.
Skill-based wagering, because you're betting on your skill against another person.
That's right, and it's not just sheer luck. It's not a game of chance. There's obviously some chance in it. Whether or not the 49th straight run by your running back causes a fumble, that's obviously decided by software. However, if you take a break and you run 25, then you take a few break, then you run 25 more, the chances that he fumbles is lower. Mm-hmm. So really, I think the skill in learning that is, certainly part of it. I think, honestly, the outcomes of things like fantasy football, all that will be totally different when, cryptocurrency and blockchains are involved in it. Maybe for the better. Hopefully it'll still be just as easy, but we'll have an immutable way to decide winners and losers and to track that over time. So I think, crypto's got sort of a really good runway when it comes to, gambling, when it comes to skill-based wagering, video games. I think that's sort of the new realm and how it's really going to shine. Rather than, the DeFi and all the different things that it does now. But, a lot of it is still certainly vaporware, too. I mean, that's another thing that we should probably mention.
Yeah, I think one of the big exciting opportunities for crypto to get big would be if they did voting on crypto. Everybody had vote. I mean, look, they had a lot of problems. We had a lot of problems in our elections. If politicians are serious about having real elections that are transparent, I think crypto is the way to go.
Sure, and I think that's a great point. So, Russia wouldn't have any way to come in and control our election, and Trump, the Manchurian candidate, wouldn't have been elected had we put blockchain protections on everything. My thought is putting the voting ballots and using a wallet to confirm your identity. These are fantastic ideas. Lots of people talk about how it's hard sometimes for certain people to get IDs. That's the biggest thing. Is should you have an ID? Well, why not just give them a wallet? A wallet's free. Mm-hmm. A wallet is a way that they can confirm their identity, and from there you can vote with a token from anywhere in the world. You don't have to show up on election day in the long lines and the heat. You just vote. And I think that would fundamentally change really the percentage of people who vote, which I think is, ghastly low over the last few years in the, 30%. Yeah. Now, it gets higher for certain elections, obviously, but, in general, it's not where it should be for a democracy, which I know we're a constitutional republic. However, everyone says we have to defend democracy.
We do. If it's up at issue, then we certainly must defend democracy, or defend a republic at least. I mean, I think that's a very key talking point for both sides of the aisle.
So this may be, sort of our second podcast. This is, by the way, our first podcast, and at some point we'll have an introduction to each of us, and we'll go through, who we are, what we do. But I think this was just a good discussion to go through Chevron, which is an interesting, case that was overturned, and Loper Bright, which you can now go fishing without having to pay the government to count your fish, and we're coming up to the top of the hour. So, is there anything you want to cover that we didn't cover?
I can't think of anything that.
I would like to shout out to Pez and the cherry flavor, because I've had very recently, and I always thought Pez was good, and then
Pez is awesome.
Okay, however, you're probably only eating the cherry, because the cherry's damn good. The other flavors, the other two flavors I had, one of them I believe was strawberry, which was edible, not good. The other flavor, and I don't remember what it was absolutely disgusting. I spit it out and threw it away.
Really?
However, cherry is really good. So apparently, every time I've had Pez in my entire life, it must have been cherry, because it was delicious.
Oh, see, I've had every kind of flavor. I like them all. But candy's a very personal thing to people. But when it comes to Pez, I eat it all, man.
No, I agree. So I'll have to give you my nasty Pez next time.
Yeah.
I also want to shout out to Michael Jackson, who wore a zip-up hoodie and a blazer on the cover of Thriller album. Yeah.
I like that.
Yeah.
Like that. Shout out to old Michael. Shout out to Dominique Wilkins. You are a bad motherfucker, dude. You better than everybody. What's up? I remember you.
Zlatan Ibrahimovic. We need to shout him out as well. One of the best football players of all time.
Foosball.
And, probably Larry Zonka.
Larry Zonka, absolutely, dude. He should be Larry Zonka.
And I'm going to go out on a limb and say Roger Federer.
Fucking, yeah. Roger Federer.
And Martina Navratilova.
And Janis Joplin.
And Janis Joplin. Yeah, that's good, too.
Yeah.
That was a sad sort of decade of losses with Jimi Hendrix.
Yeah.
And Janis Joplin.
Fucking JFK. all of them.
JFK. Well, we have RFK now.
With RFK Jr. And what is he? He's supporting Trump.
He is. I do have to mention though that we were both at the Rare Evo Las Vegas crypto. I want to call it a symposium, but it was more like a meetup. There was a RFK Jr. booth.
Right.
There was an RFK scheduled speech, which turned into a sizzle reel, and he didn't show up. So to me, I'm a little hurt.
Well, at least he got out of the race, dude. He's supporting the guy that showed up big for crypto. He's supporting Donald.
Donald does have his own token.
Does have a token, eh?
And so
DJT?
His token in his coins, it's really his token. I believe if you owned enough of them, you actually got a piece of his suit that he wore when he took his mugshot.
Oh.
So he launched, and I don't remember the name of the token, but if you owned a certain amount of them, you got a piece of his suit in a nice, I don't have one. That would be kind of cool to have.
Cool.
In a nice sort of case that you can display it. And I believe you also got to visit a dinner with Donald Trump as well, if you had enough of the tokens. I think you still maybe had to pay some money, but you had the ability to buy a ticket if you own that crypto. Now, there was some controversy recently about Donald Trump Jr. and which project was actually his that he was coming out with. So he announced that I am coming out with this crypto project. A fake Trump crypto project came out, which was not the Donald Trump Jr. project, and it pumped and it dumped, and now he has created a Telegram, which you should follow to look at that if you are interested in the official Donald Trump Jr. crypto project. It's on Telegram, which I think our next podcast, maybe we focus on freedom of speech across the countries and maybe the lack of freedom of speech in the European Union, which I think surprises a lot of people how totalitarian and, dare I say, fascist it seems. So if I were to go to France and spouted something that they didn't believe in, I feel like I could get arrested for that.
Yeah, and the place that, let's think of it. Back in history, the French Revolution is sort of the fountainhead of free speech. That's actually, Jared, what it used to mean to be a liberal is that you believed in free speech.
That's right. Well, it's Democrats, which are the democracy.
Right.
They are...
So the people. It's supposed to be the People's Party.
That's the People's Party, and it's, shouldn't be beholden to any governmental agency, shouldn't be beholden to any corporation. They were the anti-corporates. They were Woodstock. They were anti-war, which I'm probably going to get a lot of heat for this. But, as an aside, my favorite president is Richard Nixon.
I appreciate his style, He's all like, I can appreciate a guy that
so he resigned.
That much.
And then you and I were born when Ford was president, like right after that.
Right. And the only president I can remember seeing, and I was a really little kid. It was during the Muppets. I'd be watching the Muppets. I was a little boy watching the Muppets, and they'd say something about President Carter. I said, that guy's pretty cool. But then I feasted my eyes on Ronald Reagan, and he became the coolest son of a bitch in the world.
So, he was an actor.
Yeah,
so, honestly, that would sort of be like Robert Downey Jr. Well, not exactly. But honestly, he was relatively famous. He was in charge of the Union.
Yeah.
And all of a sudden became president. So, that's a big shift from where we were to where we are. And, maybe we'll end it on this, but as my dad always said, the pendulum swings and then it comes back. So maybe we're due for a pendulum swing, because I think it swung extremely hard in the last 4 years to one side, and perhaps and really longer than the last 4 years, but I think it's extremely evident of the pendulum and its progress over the last 4 years. I think we've seen that, and perhaps we're due for a pendulum swing back. And I think so. Maybe we'll talk about some freedom of speech and the UK riots and where we are with all that. It's an interesting world.
Yeah, I mean, we'll talk about why do these governments want to replace their citizens with foreigners that aren't born there? Is it because they're easier to control?
Or is it truly just a humanitarian effort to help nations and to help people that are, under persecution for religious freedoms? I don't know. It's an interesting question.
It's not human. My understanding of human nature forbids me from accepting that it's for humanitarian purposes. There's something messed up out there.
But wait, we got to tease this. We can't dive in yet. We got to tease this as probably our second episode.
Yeah, we should talk about crypto more and less law.
More crypto, less law?
More crypto, less law.
All right, so we're going to put a poll, and for all 9 of you that are watching this, mostly our families, please vote on whether you'd like more crypto and less law, or more law and more crypto. Those are the options, right?
More law and less crypto.
Now, how about more law and more crypto, or more crypto and less law?
And very little, stupid outbursts.
I'm excited.
I'm pumped, man. Really excited. Great episode.
So I wanted to shout out one more time to my SB Dunk High Nikes.
Yeah. And I'll shout out to Ronald Reagan. Remember he appointed that Sandra Day O'Connor?
Yeah, he did.
Yeah.
Yes,
and then I like Nixon too. Anybody that paces and gets that paranoid, that bad, that's my guy.
So was Nixon framed by the CIA? That's episode 3.
Yeah.
Yeah. This
That's
is gonna
part
be
of
good.
it.
Anyway, this has been the first episode of Jared Legal's podcast. And if you have any questions, please email us below. Peace.